watch it before you show other people. Good evening. Welcome to Reasonable Doubt. I'm your host, Todd DuPont. Reasonable Doubt is a weekly live call-in talk show sponsored by the Harris County Criminal Lawyers Association. Typically deals with matters in the criminal justice community. Thank you for tuning in tonight. We're certainly happy to have you watch this evening. Let me start by introducing my co-host, Mr. Quentin Tate Williams.
Evening, Todd.
How are you today?
Fine as kind. Yourself?
Well, that's a much better answer than the one you gave me last week.
Oh.
I think you had a bad week last week.
I had a bad day.
You had a bad day that day?
It was rough, challenging.
You back on track?
Yeah, the itch is gone.
Thank goodness. Our guest tonight, a friend of mine, a gentleman, a scholar, David Mitcham is going to be here with us tonight. David, how are you?
I'm doing fabulous.
How long have you been practicing?
I've been practicing since 1979.
1979.
1979.
You know, David holds a record that I believe is only broken by our friend Norm Silverman, which is the most time spent at the University of Texas at Austin. Was it an even decade, David?
Substantially so. From 69 to 79, I matriculated at the University of Texas at Austin and undergraduate in law school.
Well,
soaked up knowledge. That sort of thing.
Now, Tate, you had the opportunity to work under David. Is that correct?
About 2.5, 3 years.
Right. So he taught you all the tricks of the trade?
He taught me what he could, and I'm not sure I absorbed it all. I'm still learning.
Well, let's jump into the topic. Tonight we're going to talk about assault, the offense of assault. We're going to talk about the defense of self-defense, which those two typically go hand in hand. We were talking earlier, prior to the show, about the statute of assault. The statute of assault literally goes from a traffic ticket and can be used all the way up to a capital murder, depending on how they plead a case. The assault statute goes all the way across the boards, gentlemen, just kind of depending upon the facts of that particular case. You could have one that's a ticket, wind up in JP court.
Could also be a family violence, even in JP court or in the City of Houston Municipal Court.
So let's kind of start with that. Assault.
Well, basically the most common assault that we're likely to see in Harris County, day for day, week for week, is a Class A assault, usually on a family member.
Right.
David, I know, has tried a number of those. It and is probably the second most common misdemeanor case tried in the county criminal courts at law in any county in the state, either even or greater than DWIs.
Which we'd probably all agree is right. I mean, they're neck and neck in terms of ones that get tried.
Yes.
David, why do you think that is?
Well, I think it's because of the broad nature of Class A assault. It's any kind of contact, physical contact, which causes pain.
Right.
Even the most minor pain can constitute a Class A assault. And so to get higher than that, you'd need serious bodily injury or some prior misconduct. But because all it requires is pain, it covers a pretty broad swathe, whereas your Class C assault, like you were mentioning a few minutes ago about getting a ticket down in municipal court or justice of the peace courts, that's an unauthorized touching.
Right.
It'll get you there, where there's no pain involved, but you've invaded an offensive contact of any nature. That can constitute a Class C assault. So anything that causes pain up to serious bodily injury is in that Class A range. And it's a serious matter for anyone that doesn't want to spend a year in jail.
Right.
Because the range of punishment is anywhere up to a year in the county jail and up to a $4,000 fine.
But there's another rub besides that, because as we know, oftentimes Class A assaults are, they'll offer you a deferred. They may even offer a Class C if the case isn't particularly strong. But there's another rub called the affirmative finding of domestic or family violence.
We're going to spend some time with that because that's really, really important,
okay.
Even in a Class C context.
Exactly, because that never goes away. That is a permanent scar on your permanent record.
Like herpes.
Exactly. I mean, there's no getting around it.
The gift that keeps on giving.
Exactly.
It is.
Exactly. And once you're on the list of the affirmative finding of domestic violence, well then there's a lot of repercussions. For instance, your gun rights are substantially
They're
Right.
gone.
gone. Yes.
They are gone. For all intents and purposes, they're gone.
Certainly on
Yes.
the federal side.
Yeah, that's what I mean. I mean, they're gone. You could petition to get them reinstated, but they're not processing the application, so it'll never get granted, so they're gone.
And
Let-
woe to you if you get into a second domestic assault, because that's a felony, even though it
With-
may be of the most minor, on the most minor basis. Even a Class C, a second offense is always a felony.
A third-degree felony. And here's the bonus on that. Because what would ordinarily be a Class A assault is now a felony only by reason of the prior, that's a jurisdictional element of the offense, and the jury gets to know about it during guilt innocence that you have the prior domestic assault.
Let's kind of back up a second, gentlemen. I mean, my observation about family violence seems like it probably, we now actually have family violence sections in the district attorney's office. Correct?
In the larger counties, and I think family violence is actually a misnomer because
Or domestic violence.
Right. Well, the definition of a family member, as it comes out of the family code, and it can include a girlfriend, ex-wife, somebody who's not technically in what you would ordinarily think of as your family member.
Right.
A roommate. If
True.
you've lived with them and they're in the household, so to speak.
Two
in
brothers
Kansas.
get into a fight, like as brothers do.
Now, when there's an allegation of family violence, and typically if they meet the criteria for the statute, I want to go back a second. These prosecutors take that really, really seriously at this point. I'm alluding back to O.J. Simpson. It seems to me, my observation was that's kind of where it started, with the idea behind it that, listen, if a spouse or a girlfriend or a family member says, look, this person's been harming me, and y'all haven't been accepting charges, and then ultimately,
No, I agree, but I think it
murder
goes back
occurs.
further than that. You look at, say, there was a movie made starring Farrah Fawcett in the late 70s, early 80s called The Burning Bed. And at that point in time, the pendulum was probably at the opposite end of the arc from where it is now to where, a woman, everybody would know she's beat up, and they call the police, and the police wouldn't do anything. Now we're at the opposite end where in some states, even if the officers don't think that something's actually happened, they are required by state law to make an arrest and let the courts and everybody else sort it out later.
right.
And one of the watershed events that occurred in state law is the loss of the spousal privilege not to testify. They took
Right.
that away. The legislature decided that women, primarily women, didn't need that anymore. And sometime in the mid-90s, I believe, is when they did away with it. Prior to that, in a marital situation, if there was a domestic assault where typically the husband is charged with assaulting the wife, if after the passage of time the husband and wife decided to try to work this out within the
Right.
context of the marriage, the authorities allowed them to do that, and the wife had the option of deciding not to testify, that she just rather settle this within the context, the domestic context. And
Right.
when I was a prosecutor in the early 80s, that's the way the law was set up, and many times we had cases that would be fully prosecuted today that were dismissed back then
Right.
because 3-4 weeks after the event, the wife would come in and say, well, she doesn't want to testify, and if she didn't want to testify, we could make her testify back then.
Right.
Now, that's all gone. If she is purported to be the victim of domestic violence,
Or the children are.
or the children, or anybody in the household, she has no spousal privilege not to testify. She is required to testify just like any other witness. And many, many times we have situations where it's very murky as to who hit who first, or exactly
Right.
what occurred in this and what the provocation was, etc. And there's a call, a 911 call, and many
2:30,
times,
3 a.m.
sure, and many times the woman just
Right.
wants the police to remove the man from the household, and doesn't really particularly want him to go to jail at that time, just wants him to go away. Well, he certainly does go away. He goes downtown, he gets charged, And the next thing you know, they're spending substantial amounts of money in his defense, and it's, as I say, many times it's more murky than black and white, and the woman then wants everything to go away and thinks that she'll just go down to the DA's office and drop the charges.
Right.
And then she's informed that
She can't.
no, sister, you're not going to drop anything. You're going to get in line with the rest of the witnesses, and you're going to testify, and we're going to make you do it on pain of contempt of court.
I tell you, one of the things that I absolutely hate to hear, it's the most annoying thing in the world to me, it just makes my ears just burn, is when somebody says, I want to drop the charges.
Right.
It's like dropping a football. You have to hold it in order to be able to fumble it or drop it. They don't have it. It doesn't say, you know, Mrs. So-and-so versus Mr. So-and-so. It's the state of Texas.
Right.
And they'll say, well, the state picked them up. Nope, the state always had them. From the second you pick up the phone and call the police, you have lost control. It is not your case to decide what to do with. It is the government's. It is the state of Texas versus whoever that defendant is. But we have this perception out there in pop culture because of television that somehow the complaining witness in domestic violence cases carries the football, and they don't.
You know, it's funny, but I think you actually told me this comment. A domestic violence assault is a DWI that got away that night.
The DWI that got away is the hit and run. The domestic assault is the DWI that got home.
Okay.
Okay. A lot of my domestic violence cases come in late at night on a Saturday night, early Sunday morning, 2:30, 3 o'clock in the morning.
I was right on the source, correct?
Oh, cool. Yeah, you were. And I will also, Larry Stanley was called the hit and run, the DWI that got away, and I added to that the DWI that got
Right.
home. So anyway, generally one or both people involved are under the influence of something that's
Right.
not water. And so that, as David said, makes things pretty murky, particularly in retrospect, because, you know, when you're intoxicated, you know, memory just doesn't work too good.
Right.
And the other thing is that a lot of times, even intoxication or not, people have arguments and they want peace and quiet. And one way to do that is to get the other person out of the house. And you can do that by calling the police and saying something that you may regret later.
So let's talk about that specifically. Let's assume that the female gets upset, there's a fight, perhaps some bruising, something happens, she calls 911, goes down to a substation, we've all had these cases, and files a report. Charges are accepted, warrants issued, said husband, boyfriend's picked up. And said lady later says, you know what, not only do I not want to testify, but I'd like to write an affidavit expressly saying I don't want him prosecuted. What happens? And we've all done this. What happens in that situation?
Well, generally speaking, the prosecutors take the position that no, what you're saying now is the
Battered
result
syndrome.
of influence that you've come under from either family members or regret or whatever, but you were telling the truth when you made your outcry, and we don't believe your new affidavit, so we're going to press forward anyway.
They can still go forward even in light of sworn testimony that you don't want to go forward.
Oh, certainly. Certainly they can take the position that what you said initially was the truth, and now you're crawfishing. Now they do, as a result of recent Supreme Court decisions, they do have to produce the woman in court
Right.
To testify, but then they can cross-examine her with the statements that she allegedly made at the time.
We're gonna get into. I want to get into that.
Something that's interesting is David and I tried a case years ago. Well, we tried several years ago, but in one particular one that always sticks out in my mind, David was doing jury selection, and he asked the potential panel members why someone might change their story from what they told the police one night. And there were probably 8 different veneer members, that's potential jurors, that gave an answer that he asked. Well, what's the reason? And one person said, well, they're under the influence. Another one said, of the person now, trying to force them to change their story. Another person said, well, they're afraid. Somebody else said, they've got a psychological issue. And what was fascinating to me, and David pointed out to him, is not a single one of them said, because they were lying that night and now they're telling the truth.
Right.
And that's the mentality of a lot of jurors that you have to that you have to flush out during jury selection in one of these cases is a lot of people just don't think that women lie about domestic violence when it happens.
Because perhaps in some situations they can, especially if they know somebody's already been down.
That's right.
I'm not saying that's happened, but if you have that card,
I will.
Well, and for many of our fellow citizens, they need to understand that the most dangerous animal in the jungle is the one sleeping next to you. So bear that in mind in your conduct and in your conversations. That all it takes is a phone call, because one thing I can guarantee you under the present regime, that if a police officer makes a house call, somebody, usually the old boy, is going downtown to the Hooskow.
Right.
that night.
That night.
That's what I was alluding to earlier about, the pendulum having swung the other way. Is it's better in police practice, at least this is the prevailing opinion, to go ahead and arrest somebody and get it all sorted out later in the courthouse, rather than have a statistic on our watch where it's like, well, this woman called the police or this man called the police 15 or 20 times and nobody did anything, and here she is dead, or here he is dead.
Right.
And real domestic violence does occur, but a lot of false allegations of domestic violence occur too, because people know how to ring the bell.
Well,
It's an excellent way to get the upper hand in a divorce proceeding.
It sure is, or child custody proceeding, or in just a dysfunctional relationship.
I want to take a second to remind the callers to please call in 713-807-1794. This show's for you. Perhaps if you have an issue like this, now you have an opportunity to talk to three lawyers about it. I want to talk about, we all know this case called Crawford. The case name doesn't matter.
And
the ideas
Davis and
behind it does, which is, let's say, spouse, whichever side, that's the complaining witness, says, you know what, I don't want to go forward at this point. I've even given an affidavit that says I don't want to prosecute, and the state says, too bad, it's not your decision.
Or how about an affidavit that says it didn't happen, I made it up, I was drunk, or the officer put words in my mouth?
You could have an affidavit that says anything. You could build in defenses, which we're going to turn to shortly.
As long as it's true.
Right, well, it's sworn to. At that point, let's say that person doesn't show up.
They're not able to secure process through no fault of the defendants.
Right. So what happen? I mean, what happens in the courthouse, guys, in that situation?
Well, presently now they can't go forward if the statements that were given by the complainant were testimonial in nature. In other words, if it would by analysis it appeared that this would be used to prosecute the defendant, well then under the Confrontation Clause of the Constitution, he has a right to confront her in open court and be able to cross-examine her, and that the state can't go forward with the hearsay that they were using for quite a while. For several years, the prosecuting authorities here were able to bring in police officers when they had a missing complainant and say, well, on the night of the incident, she told me that he beat her up, and she did so in an excited manner, so it's an excited utterance, and it's a exception to the hearsay rule, and it's impossible to cross-examine the officer, because all you can say is, well, no, she didn't. Yes, she did. And of course, by and large, the jury is going to believe that the officer is being truthful, and he probably is being truthful in terms of what she said that evening, but that doesn't necessarily mean that what she said that evening was in fact true. And that's why you have a right of cross-examination, which is, of course, the greatest engine ever devised by the mind of man in order to get to the truth. And so, fortunately, the United States Supreme Court, in a aberration from their usual right-wing trend, has decided that the American citizens and anybody in a court of law is entitled to the confrontation of the witnesses against them, and allowed to cross-examine them. And so now they can't do that. They in most cases, they have to produce the complainant.
Yeah, I'll take the call.
Hi, caller.
Good evening.
How are you this evening?
All right.
Well, thank you for calling. I appreciate that. You are the first caller tonight.
Wonderful.
Talk to me. What's happening?
Well, I'm watching the current conversation.
Right.
If I need to move away from the TV, I will.
I don't hear feedback, but it's always nice for you to turn it down.
Well, I'll move away.
You can watch it in syndication.
One thing this conversation brings to mind is a editorial that was in the Houston Chronicle,
All right.
and this must have been maybe as long as 5 years ago, and I believe it was by a reporter named Tom Marshall.
All right.
Are you familiar with him?
We
Yes.
are.
Well, he said that the district attorney's office said it was very easy to convict someone that was guilty. But what was the real challenge was convicting someone that was innocent.
Now, who made that comment? friend?
Apparently not, based on all the people exonerated by DNA.
Hmm?
I said apparently it's not too hard to convict the innocent if you look at everybody who's been exonerated and let out of prison based on DNA evidence.
Alone.
Well, I'm not discussing DNA evidence. I'm just discussing this comment by an editorial in the Houston Chronicle.
Well, if I could respond to that, I think that's apocryphal. I don't think prosecutors want to convict innocent people. I don't think
most do.
Well, okay. I think if they're in good faith. I think they're in good faith. Sometimes inadvertently they get overzealous, like just by the nature of their work. But I don't think that any of the prosecutors, frankly, are hell bent to convict innocent people. I think that they want to do right.
David Mitcham.
I'm sorry?
One of your panelists, David Mitcham.
That's who you're
That's
talking
who-
to right now, my friend.
Okay.
Who?
You're talking, well, right now you're talking to Todd DuPont. Who was responding to you as David Mitcham.
You're not David Mitcham.
All right.
David Mitcham used to be in the district attorney's office.
Right.
I did, yes.
What I'm
Apparently
What-
this man is from the general public.
what I'll
and he's
suggest
somewhat
to you,
confused.
my friend.
Hey, why don't you just let David talk? That's who he wants to talk to.
Well, did you want to talk to me, sir?
Well, evidently I'm not talking to a live recording.
Okay. Well, nonetheless, I'll still answer any question that you might
Tell him
have.
who you are.
I'm David Mitcham.
David,
Yeah.
this is Tom Rackley.
Hey, Tom, how are you doing?
Now we're working together on the verifiable voting committee.
We are, and I'm glad you brought that up because it sticks in my craw that we don't have a paper trail to our ballot, and I think we're heading towards some kind of scandal, Tom, at the
Well,
next election.
Are you aware that we just met with Brad Friedman, or Stan and I did briefly,
Right. Okay.
after he was here in Houston, and that's another subject.
That is another subject.
But
Although something's got to be done about these voting machines with no paper trail.
Can,
well,
We're
Brad
kind of
Friedman
off message
says
here, but
that even the audible.
Let me do this. I'm going to line you up with David Mitcham's cell phone after this, and you guys can talk to the cows come home regarding some of these other ancillary matters. Otherwise, this is going to be a private conversation that
Well,
Tate's not really going to be interested in.
Actually,
Don't
David and I are
remember.
very interested in the voting machine issue, and I'm just not.
David, do you not remember the Tom Marshall editorial that he quoted some district attorney prosecutor saying it was easy to convict?
well, but Tom, I think he was being facetious. I don't really think he was being dead serious.
Well, that may be the case, and you may know Tom Marshall better than I do.
Well, he may have taken it seriously, but it's hard for me to. I know the prosecutors by and large. I just don't think that they're really after innocent people, Tom. I mean, they
not
have
the
their
ones
faults.
here. There's some around the country that do.
I'm only familiar
engage
with Harris County, but I.
Well, I understand, and I hope you're correct. And I brought this up to a mutual friend of ours, Kenny Rogers.
Okay.
The country singer or the pitcher?
No, the investigator from the district
Former
attorney's office.
investigator.
Yeah.
Oh, sorry.
There's a third Kenny Rogers? You're saying there's a third Kenny Rogers?
There's a third Todd DuPont.
There's probably several others. There's probably multiple Kenny Rogers.
How many of them were conceived to a Kenny Rogers song?
Let me do this. This is getting out of
Kind
hand.
of veered into the surreal here,
Right.
Tom.
Thank you for calling, Fred. I mean, we could go hours with this.
With a Kenny Rogers game on in the background.
Oh,
even.
my goodness.
It's great to hear from you, Tom.
He heard,
He heard-
you on,
all right,
on
okay.
live television.
All right.
Okay.
Where do you go after that? I mean,
Back to the
How do we
question.
segue back into
You know what?
self-defense?
There are a lot of innocent people that get convicted. I think the statistics on DNA exonerations are a good way to bear that out. I don't think, by and large, that the vast majority, I mean like 99.999% of prosecutors, I think they're just trying to do their job and the right thing. There are a few bad apples out there that, do engage in conspiracies to convict innocent people. I think Clarence Lee Branley might have something to say about that. I think the guy from Adams v. Texas might have something to say about that.
Right.
And
I do think that at times they get blinded by partisanship and lose the focus. They're just they're human beings like everybody else.
That's right.
And
But I think the vast majority, are just trying to do what they perceive the right thing to do it in a case at a time, and that's why we have an adversarial system.
well, respectfully, I mean, you're going to run into prosecutors, not necessarily senior prosecutors who've been around a while and have tried 40 or 50 felony cases, but perhaps, at least in the culture of the Harris County District Attorney's Office, where they're trying to make a name for themselves.
Well, I think the bigger problem is that you're alluding to is one of personality. And for example, you get people that get married to their case on both sides of the bar, not just the DA's office, who can't remember that everybody's a professional here and that that's what juries are for, and they take things personally. Maybe they take them home with them. I don't know. But I have met people who made cases personal,
Right.
or tried to substitute for or make up for their own inexperience and incompetence with an aggressive personality that really put everybody off. David has probably been the master, at least from what I've seen over 8 years, of getting along with everybody. And when the three of us taught at a CLE recently, one of the things that he taught to the attorneys in attendance is that, there's always another case. Could you explain that concept, please?
well, you can't go overboard on one case and do something improper because in the furtherance of your ends for that one case, because next week you're going to be dealing with the same set of
Right.
prosecutors where they're going to remember. So it's in criminal law, especially as it's practiced in Harris County, because you see the same defense attorneys and the same prosecutors over and over again.
It's like
you
high
have to be. It's like suspended high school, and you have to be a person of your word. And if you don't, word gets out, and you can't function.
Right.
And over the course of the years, we've seen lawyers come and go that couldn't function in that arena because they couldn't keep their word. Now, over in the civil arena, it's different because you're less likely to see the same lawyer ever again. There's about 15,000 of them,
Right.
and so everything has to be reduced to writing. And and of course, they're talking about money as opposed to
Right.
liberty, freedom, and that sort of thing. So it's a much more sharky and snaky over there. Whereas over in the criminal context, you have to be a person of your word, basically, and if you're not, you can't function on either side, either prosecutor or defense attorney.
I asked a senior lawyer mentor of mine years ago, I said, how do you deal, you've been doing this for damn near 30 years, and I'm going to ask you the same question. What I asked him was, how do you deal with a prosecutor that's been licensed 6 months? I mean, what do you do when you know you're right and they know they're trying to get ahead? I mean,
Well, you have to consider the source, and in my particular circumstance, I remember I was probably insufferable as a young assistant district attorney, and I figure that they'll learn more as they go along. And the great thing about the courts of law is that they got to back up with what they say, and
Right.
and if they're wrong, it will come out if they're called on it. And just, they're not going to buffalo an experienced lawyer that's in the right.
If you have no integrity and you're gutless and you don't try cases, everybody's going to know very quickly.
Right.
And you're going to get treated accordingly, regardless of which side of the fence you're on as a defendant or a prosecutor. If you're a kiss up, kick down kind of guy, what did I hear? And
That's cool.
I think that was used
Did
to
you
describe.
just make that up?
No, that was used to describe John Bolton when he was
Right,
going
right.
through the UN ambassador process.
And
Nomination
it
process.
apparently works there at the United Nations, but in the Harris County Criminal Courthouse, you have to treat people with respect, and on both sides. And
Yes.
by and large, I think that does occur. I think we have a pretty good system.
It's
I mean, there's
pretty
some
collegial.
problems. There's some problems, but the prosecutors are zealous, and the defense bar is zealous, and everybody works and has a good time. And by them taking a very aggressive approach to domestic violence and other assaults, there's work for everybody.
That's right.
Another development, getting kind of back on message about assaults and self-defense and that sort of thing. The recent change in the law, by recent I mean the last 5 or 6 years, where they're now allowing people to carry guns with your concealed handgun licenses. And I'm in favor of the Second Amendment. I'm in favor of having an armed population and that sort of thing. However, just so that you would know, if anybody's watching this show, that the chances of you being able to stop a mugging or a robbery or protect yourself on a murder, that sort of thing, the odds of that happening are dwarfed by the odds of you getting arrested by the police, or a kid getting the gun, or an accident occurring, or you shooting yourself in the foot. I think that it creates a much more dangerous environment with people running around with these guns. And we see it down at the courthouse. If you've got a gun on your person, even if you've got the concealed handgun license, you are more likely to get arrested. You're more likely to get into these kind of scrapes. And you need to understand, if you get these concealed gun hand license, you better be especially careful, because if you get into any kind of situation with the authorities, it's going to be much worse than it would be if you did not have a gun.
You're held to a higher standard. Hi, caller.
Oh, hello.
what-
My question is for David Mitcham.
How are you today?
Oh, I'm excellent, actually.
Great. Well, please. That's why he's our guest this evening.
Now, I watched a trial that David Mitcham put on, jury trial he put on in 1994. And he represented an attorney. He was representing a lawyer that wasn't actually found guilty by the jury because, as we were watching, the case was falling apart. And I think David Mitcham did a great job. I've always been fascinated with his work. But at the same time, I was wondering, when you were representing that attorney, what was the difference? How is it different in representing an attorney than actually just representing a lay person? And the second part to my question, Mr. Mitcham, is that now that we're accelerating, 14 years later, do you look back on that case and wonder what it is you might have done differently at all?
Well, I distinctly remember the case that you're making reference to, and I was representing an attorney that was charged with taking money that he shouldn't have taken from a client, and the evidence sadly was overwhelming, and we resolved the case with a plea before the court before the jury was able to do what I anticipated they would do, which would not be in my client's interest. So the case did disintegrate mid-trial, and it's especially burdensome to be representing an attorney because of the propaganda against attorneys that the past generation we've had to endure. Even though attorneys are the bulwark to protect all of us in our constitutional rights, we have been castigated by the media. And I think it's very dangerous in our society to castigate lawyers the way we have, because it is the lawyers that protect the average American. The super rich really don't need lawyers. They've got so much money that they'll do just fine without them. But the attorneys represent the little people, frankly. And in a court of law, even the high and mighty can only be represented by one lawyer, just like the average individual and the average citizen. And so we are at great peril in this country to take a negative approach towards the legal profession. And so, and so when you represent an attorney, you're dealing with a jury pool that has been subjected to this kind of massive propaganda against attorneys,
right.
and you're like a hunted animal, or your client's like a hunted animal, and you're with him in the hunt.
Did you have extra stress knowing you represented a lawyer? I'm not.
Well, certainly, because you know the prejudice that some people bear against lawyers. Some of it, I guess, is well-founded, given some of the personalities that we know within our profession. However, some of it's very unfair. And when you're getting down to the individual case, you've got to deal with it, because there are many people that are hostile to lawyers because they've bought into this propaganda campaign against us.
Tate?
David and I have represented lawyers. I wasn't involved in that case. I think I was probably
You're probably in junior high school at that time.
No, I was drinking beer at the University of Texas in Austin. Granted, not as long as you were,
Well,
but yeah. But that's where I was in 1994, and but we represented other lawyers in various, and one judge in various situations, and it is from the point of view, and I've represented lawyers in other contexts and advised them and continue to do so and fix problems for other attorneys who tend to find a way into quicksand fairly regularly. And lawyers turn into regular old clients when they become clients.
Right.
That's true.
And they behave like regular clients, and they forget that they're lawyers. And the added element is that some of my lawyer clients have second-guessed a little more and wanted to participate in the preparation of their case a little too much, to the point where we had to have a discussion about why they had to have me in the first place. And but generally, by and large, they don't. They're just average clients. Now, the prejudice in the jury pool is very real, or from the bench if everybody knows the personality.
I was sitting in court today, and a lawyer I know approached me and said a lawyer in his building got arrested by federal marshals this morning, or yesterday morning, and didn't tell me the name of the lawyer. Doesn't matter. Apparently what this lawyer said on the way down on the elevator was, I shouldn't have done that. And I'm like, well, we know that's not a criminal lawyer. He made an admission right in
I'll say
front of
one thing about lawyers getting in trouble, at least down in the criminal courthouse, is that the barracuda ethic seems to prevail. We eat the wounded.
Right. You had a second question, caller.
Yeah, my second question was this, and I need a fact-based answer from the whole panel.
We'll do our best.
Is it illegal? Can you be charged with driving while under the influence if you are completely inebriated, intoxicated, riding on a bicycle in the state of Texas?
I'm going to hang up and answer your call. Absolutely. Yes, period. That is a vehicle.
It's a motor vehicle?
It's not a motor vehicle.
No, it's not a motor vehicle.
Thinking a motorcycle you can, but are you talking about a bicycle, a pedaling bicycle?
Well, they may not hit him under DWI. They certainly can. Well, that's
Public intoxication.
Right.
Getting for that, you know.
that's a
That's a guy. I haven't thought of that. I don't think it's a motor vehicle, but a coin-operated machine includes one of those things that you stick the parking money into, even though it doesn't really have any moving parts. So,
right.
but I don't think that a bicycle.
It's not a motor vehicle, no question.
Well, I mean, I honestly don't know the answer to that, Todd. It doesn't mean it couldn't. It's not possible because, like I said, a coin-operated machine includes things that aren't machines. A firearm includes a soft pellet gun.
Certainly a motorcycle you can get a DWI, but I think if it's just strictly pedaling,
PI?
You're huffy?
I think PI is probably the worst you're looking at.
Which is a Class C.
It's probably not advisable, though, to get plastered and ride a bicycle. But
you probably put yourself at more harm's way than.
Yeah, I think it's not a good idea.
Not a good idea.
It's dangerous in either. It's a motorcycle, a bicycle, a car. You can get hurt.
Let's switch gears now. I want to talk about defenses. We've talked about the offense of assault, how it can happen, the number of different ways a person can be charged with it. You know, they built in assault against referees. I mean, we have the dads coming down. And
Well, you know, that's
let's talk
absurd.
about defenses.
Well-
let's
well-
talk about how you defend that case.
You know,
Okay, well, bear in mind the overarching theory under the law with self-defense is that you're allowed to use force against another's use of unlawful force or apparent use of unlawful force when and to the degree it's immediately necessary to defend yourself or a third party.
Right.
That's the basic underlying theory of self-defense under Texas law.
And God forbid you thought you had an account on your paper for that. You know it right off the top of your head.
That's
David.
right. That's right. Apparently, there's some brain cells still firing even at this late date.
Good for you.
All right.
Todd, how many different criminal offenses are there in the state of Texas? Off the top of your head, I know you write the book on it.
In the penal code, there are about 250, but that doesn't account for the subsections of each crime. There are over 2,500 in all the 26 different codes in the state of Texas.
There was a great article yesterday or today in the Houston Chronicle about being over-criminalized. Needing a specific statute for referee violence is absurd. It's already covered in the assault
Right.
code. We don't need specific statutes for things that are like particularized computer thefts. It's still theft.
What do you think those, honestly, and this is actually a bone of contention I have, what do you think those folks in Austin do? If they don't think that's their job to create new crimes, haven't they ever stopped?
No, it's
and
not
just
their job to create new crimes. Their job is to govern the state.
You don't think they're not, it's a self-fulfilling prophecy.
I think it's a derivation of the privatization of prisons myself, because what we have now is we now have private prisons where people are making money off of locking other people up.
Right.
And so now there are lobbyists in Austin trying to get the legislature to have more crimes so they can lock up more people with longer sentences. And so I believe part of the problem that we have in terms of the overcriminalization in the state of Texas has to do with the privatization of prisons, which I think is a very disturbing trend in the law. There are certain functions, I believe, that are fundamentally governmental. For instance, counting the votes. We shouldn't have privatized the counting of votes.
The military, we don't need Blackwater USA, in my opinion. The job of the U.S. military, or the U.S. Paramilitary forces in the form of like FBI, is an essential governmental function. The government, in a civilized society, if you want to look at what is a state versus a failed state, is a government has a monopoly on the use of force.
Right.
Okay? We don't need mercs. We don't need private police forces. We don't need farming out our intelligence services to agencies and contractors who may have political agendas. There are certain core functions that a government should do. Law enforcement, prisons is one of them.
Well, see, the profit motive comes in when you privatize prisons, which then overshadows constitutional concerns, for instance, and whether or not you're dealing with cruel and unusual punishments. And when the profit motive is the primary and overarching concern of the private enterprise, well, then the Constitution is going to take a back seat. And in areas such as jails and prisons, I think it's very disturbing. And then that leads to lobbyists going to Austin to come up with new ways and bigger ways of locking people up.
Right.
Well, there's lobbyists even for public sector. One of the largest lobbying groups, I believe, in the state of California is the one that represents the prison guards. And so if you look at the prison regime in California, some people believe and have argued that their sentencing schemes, etc., and associated disputes like the ones we're discussing are in large part impacted by the lobby of that particular union of state employees.
Well, I'm going to make my point, but I also agree that I don't believe any state legislature, I've been watching them for the last couple of years, sessions now, there's no way they're not going to pass a criminal law. I don't care what it is. They're going to pass a criminal law because they can. In 2005, and I watched this, And we had a prosecutor from Harris County that went down to Austin and testified. Doesn't matter who he is. He went down there, and they were trying to pass a new law on the breathalyzers on second offense DWIs as a condition of bond.
It's public record. It was Warren Deepron.
Well, and what happened, I wanted to see who else was in that meeting. And who else was in that meeting was Smart Start, the company that puts it on. So basically what you have is all these private interests that their stockholders and their shares are fixing to skyrocket once they get legislation that have passed
Right.
all the counties.
But I
across
want to
the
clear
boards.
something up. If I'm correct about who it was, his interest was not.
It was him.
Okay,
I'm just telling you.
I know, but I'm telling you that his interest is one of road safety. I don't think he could give a care in the world about Smart Start and them. He has a particular concern about DWI crimes. It's an area he focuses on, and he's good at it.
Right.
Okay, and I don't think that he was there in any way to lobby on behalf of Smart Start and them. Their interest is totally different, in my opinion, from his of law enforcement.
Fair enough.
They have, I mean, he gets paid the same whether,
Right.
they have the requirement or not. On the other hand, the people who make money off of the criminal
Talking
system,
about private
the private
sectors.
system, I mean, you don't go to the Harris County Probation Department to get the machine installed on your car. You
Mark,
go
do
to
I
a
have
private.
phone call? Oh, okay. Mark says I have a phone call. I'm sorry. Boy, we got on a tirade there. Hello.
Hi, how are you guys doing?
Man, I'm not too bad. Turn your TV down, brother.
Oh, I'm sorry about that.
What's happening?
Anyway, I was just flipping through. I'd like to know about he looks really interested about, he's into what he's talking about. I'd like to know what you guys are talking about.
Who?
These two guys in the suits.
The guys in the suit. Okay, that narrows it down.
I'm sorry. I'll give you one more chance.
I think what we're talking about is people that make money off the criminal justice system by contracting for prisons and other services.
Do I still have him, Mark? All right,
You know,
I
for
think-
example, the state of Texas has private prisons that import prisoners from other states, from up in the Pacific Northwest area, etc. Don't we have enough of our own jail overcrowding without having to import these people?
No, we
what
don't.
And what they're doing, and you can read about it in the Chronicle, the New York Times, or whatever, is they say, hey, we can house your inmates at X number of dollars a day, whether it's 40 or 50 or 30.
You read the New York Times?
Every day, Washington Post, London Times. The
They actually they put a newspaper out?
It's online. The internet is the greatest thing.
I'll be darned.
It's
The
cheaper than a
internet's-
subscription.
You
What's-
check out the internet.
What's the internet?
It's the place you email me all that porn from, Todd.
Please.
Anyway,
And for the record,
That's a
I don't
joke.
know what porn is, so let's
It was
make
a lame attempt at levity.
that right
But,
and terrible.
bottom line is that they say we can do it cheaper than you can in your home state. But then what happens is as we've seen from some of these articles, is that they're not guaranteeing the safety or the welfare. They're cutting corners on the health services provided to the inmates
Right.
or the quality of food. And they go to another state. And sometimes people in communities in Texas or other states aren't happy about having a prison in their community that houses people from another state.
Well, I mean, that's just sad. I hate to say sadly that's how it is, but that's how it's got. I mean, understanding that we have private prisons in this state is interesting by itself.
Well, I just think it's a dangerous trend that causes me great concern, and I think that the trend is very dangerous to our liberties. And when you have people who are pressing forward for more laws to lock up more people so that there's more profit, I mean, to me, that's a very, very dangerous and disturbing set of facts.
The bottom line is we incarcerate people in this country at a higher rate than any other country in the Western world, in the first world, the free world, whatever you want to call it. And yet we stand down at the same time and say that we are the freest country. Both things are true. Now ask yourself why that is. Do we over-criminalize? Do we over-penalize? Or are there other issues that cause this?
Well, one thing, Harris County is the tip of the spear, too, in terms of getting locked up. You want to get locked up, this is the place to come, because we will flat lock you up in this county.
Well, but you also will get a chance, typically on a first-time offender. I understand the typical recidivism rate is about 44%, if I've heard correctly, which means about 4 to 5% of the people that get probation aren't going to make it.
They
Period.
want their MRP.
And then what's going to happen at that point?
Well, how about, for example, we don't put them on probation in the first place and we just decriminalize certain conduct?
Well, then you're asking the same people who overlay statutes, they create new statutes to double crime, to decriminalize crime?
We've done it. We've done it. Greatest example in the world, prohibition on alcohol.
How long ago was that, Tate?
Probably your grandfather's time. I'm not sure how well it went over in your neck of the woods down there in southwest Louisiana.
We
But-
didn't like that at all.
No, neither did my forebears. That's how they got here. And
Have you seen this? I haven't. Have you seen a statute repealed, short of the one that went all the way up to United States Supreme Court on flag burning? And they
sodomy.
said no flag burning.
The flag
And-
burning
and-
statute's still in the penal code, isn't it?
It is, but it's not prosecuted.
As is the
But it
sodomy
wasn't
statute.
repealed.
Right.
The only way you get rid of criminal laws in this country, as a general rule, is for it to be declared unconstitutional. You're exactly right. The legislature is loath to
Say we made a
repeal a crime.
that we made a mistake.
Forget about repealing it. They very rarely lower crimes from a felony to a misdemeanor. The last few we've seen were BMV.
Right.
Um,
But they actually added that now on the third or the second or third time it's now a felony. They did September 1st. Hi, caller.
Hello?
Let's start with how are you?
How are you?
I'm pretty good. What's happening?
Are you good? Are you pretty damn good?
All right, let's get to it. What you got, bro?
Okay, don't get crunk. You stupid Bruce Willis looking.
All right, well, Bruce Willis.
yeah.
Is that good or bad?
Why
I'm
would
just
you hang up
asking.
on a guy that he's
Apparently, Todd, you've got a fan base.
No, but is
You know-
Bruce Willis good or bad?
Liv
it's movie
Tyler,
stars. It's
Demi
Hollywood.
Moore,
It's Hollywood.
the co-star for Moonlighting.
I
think he's ahead of you.
Do
by
I have a
election.
call screener? Do I have a call screener? I don't understand. What's going on here
What are you
tonight?
complaining about, Bruce?
All right, well,
Go.
oh my goodness. It's been one of those days. Really, it really has been. Hi, caller.
Hi.
Turn your TV down, dear, please.
Okay.
You can see it on a rerun. It's okay.
Oh, okay. What are your stuff is mainly about?
I'm sorry?
What are your stuff mainly about?
Okay. This is a criminal law program, dear. Do you have a question?
Yes. What do you do?
Okay. Thank you for calling. Thank you. Mark, I don't understand what's going on here.
Todd DuPont, moderate hard. You can see it now, you know.
Todd's a lawyer primarily. He's a criminal lawyer. David is a criminal lawyer. He's board certified in criminal law. I'm also an attorney. I have a little more mixed practice than these gentlemen. And we're here to talk about criminal law. To answer your question, young lady.
If you started with the introduction of the program, I typically say this show typically deals with matters in the criminal justice community. I don't want to hurt you from not calling again, but please call with the
Can you
topic.
think
She was a channel surfer. She had come on to us and wondered, what are these people babbling about?
Very
and
well.
so
I thought it was
that's
Bruce
what the
Willis.
Bruce is up there.
How
I
does
loved his
that-
last movie.
Guys,
You know?
I'm running short on time. Mark,
Okay.
do I have a call? All right, let's try to field one. I don't have a call.
David, can you think of a statute since you became a lawyer that has gone away? It's been decriminalized.
I can't think of anything really that's been decriminalized whatsoever. I mean, there has been a lessening of some penalties just
Horse
because
theft
the
is no
old-
longer a felony.
There you are. There you are. There's been some lowering of the penalties just because we've packed them in so much at TDC.
BMV.
Well, when we say B&V, that's burglary of a motor vehicle
Right.
for the uninitiated. But, you know, generally speaking, just like Todd said, once they criminalize something, it stays criminal.
Right.
I think there's a lot of statutes that they're already illegal and get a specific, type of fraud or theft because there may be a special interest out there that says, hey, this isn't getting punished enough, and hey, we're suffering some economic consequences in their lobbying group and in their state rep.
This session, they actually passed, they amended the theft statute
Again,
Right.
It was originally a consolidated theft statute to try to put everything under one umbrella.
Now they've added, and I've actually represented a gentleman that was accused of stealing copper wire.
From the cell towers, right?
Right. You know the case pretty well. We talked about it. That's such a prolific problem that they've actually added that to the September 1st changes, and it bumps it up higher. What happens is, in essence, people have gone down to Austin and said, we want harsher punishments than just what's on the books.
Well, I mean, there's a value ladder for theft, meaning that the level of crime that it is tied to the value of what is stolen.
Typically.
In that case, it wasn't bad enough.
Right. Now it needs to be worse. And that's what we're seeing.
I think really, you know, ultimately, at some point, it's just everything's automatic life or roadside execution.
Well, that's somewhat where we're getting to. We got about 2 minutes.
And I know that sounds absurd, but, you know, the reality is you bump these things up to first-degree felonies, you know, or enhanced first degrees where it's 10 to life, 15 to life. And I'm sorry, but, you know, some of these things just aren't equivalent with killing somebody.
Well, you know, I think they're really missing a bet, though, because, you know, we've kind of gone into registering sex offenders. And I say to myself, well, if we're going to have our own sex police and we're going to register sex offenders and we put them on the internets and do that, well, why not burglars? Why don't we register burglars?
Right.
And murderers. Why don't we register murderers? And then thieves, you want to register thieves too, and
Right.
your drug users and your jaywalkers, and let's just register them all.
It's for just everybody.
Sure. And then we can achieve what seems to be the goal, which is to have half of the population locked up and the other half employed in locking them up.
Right.
And that seems to be the trend, so that maybe by the you know the 22nd century we could get there.
Now, you just gave our 2009 state legislature a good idea, and I'm pretty sure that...
Well, you consider the legal fees.
Tate, any parting words this evening, my good man? I'm glad you had a good day today.
I appreciate that.
Thank you. I appreciate that.
I would like to thank David for...
Well, I appreciate being with you guys. Tate
An
and
hour
Todd.
went pretty quick, didn't it?
It did. In fact, I thought we were only here for 30 minutes, and yet here it is, gone on for...
I'll
actually,
be darned.
Imagine how fast 30 years could go.
That's exactly right.
Folks, thank you for tuning in tonight. David's one heck of a good lawyer, certainly a friend of Tate and I's, colleague of ours. We're happy to have him on. Look forward to having him again.
He also has a wonderful singing voice.
Yeah, let's talk about my rock
You
star
got
career.
10 seconds.
Well, you know, don't say nothing till the lawyer comes.
There you
DBI.
go. Folks, thanks you for tuning in. Look forward to seeing you about this time next week. Have a good evening.